It is July 27th of 2026, and this is the Court Gallery. We open in Judge Stillwell's courtroom, where we have a follow-up. A man who works at the Capitol is seeking to expand his protection order against a neighbor who seemingly still won't keep his distance. Then, we navigate a tense stalking accusation where a woman claims her elderly neighbor's behavior has forced her from her home. The only issue? He doesn't seem to know who she even is, or why she's upset. Finally, with Judge Webster and Mr. Regier, a defendant fires Mr. Patterson live on Zoom, then proceeds to educate the court with his pre-written pro se motion for dismissal. All that and more starts right now.
All right, and the next matter we're going to address is 26-270. So that's the motion to modify the protection order requested by Patrick McDonald. Come on up, sir. We've got Caragino, Mr. Caragino on Zoom with his parents. See you there. All right. Good morning.
Good morning, Your Honor.
All right. So I've had a chance to review the requested change, being the expanding the restraint provision from 250 feet to 400 feet. Is that correct? So I've had a chance to review that, given some concerns that you've identified in your request since the order went into effect. I've had a chance to review that petition. Is there anything you'd like to say in addition to that? And if so, I can put you under oath.
Okay, sir, I appreciate it very much. My comments are already in there. You already read it, so I didn't need to. I will say one thing, and I noticed what you said in the last group, that violations don't come up in this court. I understand that. The only thing that I'm going to make a point of that is that I measured all that on Monday after our hearing and realized that it was not sufficient, but I sat on it and didn't. I was like, well, I can live with it. And then the individual violated it.
If we're going to go into what's in the petition, I'll want to put you under oath, just so if we're talking about the substance of your request.
I'm happy to do that, sir.
Okay, sure. And you swear from the testimony you're about to provide today is the truth and the whole truth?
It is, sir.
Okay, go ahead, Mr. McDonald.
Thank you, and I'll just make it quick, but I was going to sit on it. I didn't think about doing it. And then within less than a week, he violated it 3 times. City of Olympia responded twice. State Patrol responded 1 time. State Patrol didn't follow up because it was already being dealt with. So that's when I decided, okay, clearly I need to be more direct and more clear with the boundaries, and that's the reason why I did this. That's all I have, sir. Okay.
All right, give me one moment. I'm going to bring this your request to modify back up here. So take a look at it one more time.
Yeah, I didn't mention that in my paperwork. I
appreciate the extra context.
Yeah.
Has law enforcement taken any action, referred charges or anything?
Well, oddly enough, the second time, the first time it was kind of late. They didn't go to the house. The second time, the policeman said he would. And I did notice that not only did the harassment stop again, but he didn't show up at the parade route, which usually happens, late for a parade route. So I think now they've gotten the message, but I didn't follow up at the city of, I don't want to exacerbate it more than it is.
Okay. All right. And then before turning over to Nicholas Caragino, just a couple of things too to clarify. So the 250 feet is from the property line too. So that's something to keep in mind as far as when we measure the distance of that stay away from, it's with 250 feet of your property line. So not just the home, but the property line itself. So, the sort of that alleyway, the street, assuming a kind of a 40-foot width there, that's all within the 250 feet. Yeah. And then the other thing to mention as well, I'm going to bring up the original order here.
I think the workplace part is what causes a bit of confusion with the state patrol. Okay.
Well, and with respect to the workplace too, and this is for the Mr. Caragino to pay attention to as well. There is the distance restriction. Also pay attention to the subsection C on the restraint provisions. There's A, B, C, and D. Only B is checked. That's the no contact. D is the stay away from with the physical geographic restrictions. C is stalking behavior. And so that's irrespective of a distance, is there's a prohibition on harassing, following, monitoring, keeping under physical electronic surveillance, tracking locations, things of that nature. So that is even outside, 250 feet, outside of 400, 500 feet, 1,000 feet, whatever that restriction is, that's always a restriction. And so I think you mentioned in your petition, in your request to modify it, kind of allegations of Mr. Caragino standing outside kind of by the Supreme Court, looking through the office window. There's also the stalking behavior restriction there too. And so a couple of different restrictions I think may come into play based on this. So, all right. Okay, so we've heard from Mr. McDonald. For Nicholas Caragino, if you'd like to respond, I can put you under oath if you'd like to respond to the allegations leading to the request here for modification. And you're all on mute here still.
Need to speak up.
Can I?
No, stop, Nick. I have two representatives with me for Nicholas. They're here just as character witnesses and as friends of Nicholas that have information.
Sarah Coates and Jackie Keening are here as well.
All right, and I was the original judicial officer and I remember I allowed testimony from Mr. Caragino's parents. And I'll allow non-parties to, just to make a record here, non-parties are allowed to participate in these proceedings if their testimony is necessary and material to making a decision. From my review of kind of the original allegations and Mr. Caragino's sort of ability to assist himself in these, I thought it was appropriate to hear from his parents. Sounds like there's some other folks here who'd like to kind of speak on his behalf. And I heard from non-parties at the original hearing. I think it's appropriate to hear from non-parties today as well. I will have to put you under oath, so everything you say is going to be under oath. And so for those who would like to speak, it sounds like there's two others as well.
They're coming around.
Coming around. I don't think it's
Nicholas.
Okay. Could you all please raise your right hands? All right. Do you all swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Yes, we do.
All right. And before I'll let the record reflect that all five non-parties here have sworn the oath. Before providing testimony, if you want to provide your full name and spell that so we have it on the record, and then you can go ahead and let me know what you'd like to say. Okay. So whoever wants to go first, go ahead and just make sure you spell your name.
I'm Jan Sergino, JanCereGhino.
Okay. And go ahead.
Jeff Seragino.
Well, I think what we'll do is, I think what we'll do to just kind of make the record easier in case is once somebody identifies themselves, if you want to provide your testimony, and then we'll move on to the next person. I think that will just be a little bit easier for keeping track in the record.
That's a declaration.
Go ahead.
Declaration of Jan and Jeff Sergino. In opposition to the petitioner's motion to modify or terminate protection order number 26000270, we, Jan Sergino and Jeff Sergino, declare under penalty of perjury under the laws of the state of Washington that the following is true and based on our personal knowledge. Number one, background and respondent's living situation. 1.1. Our son, Nicholas Sergino, has lived at 203 20th Avenue Southwest in the Capitol neighborhood in Olympia for all 33 years of his life. 1.2. The petitioner, Patrick McDonald, seeks to expand the existing 250-foot restriction to 400 feet, asserting that Nicholas has opportunities to view his home and workplace. 1.3. Nicholas walks through the nearby streets because they provide safe and familiar routes to essential destinations, including the homes of close friends and family and relatives who live within this boundary. 1.4. Nicholas avoids Capitol Way due to heavy traffic, noise, and sensory overload, which are particularly challenging for individuals with neurodivergent conditions. Walking through the campus and adjacent streets is a necessary accommodation for him. Number 2, community involvement and transportation limitations. 2.1, Nicholas is an active participant in the Olympia community. He cannot drive and is fearful of public transportation because he was assaulted and robbed, so he relies on walking and occasional rides from family and friends. 2.2, his activities include serving on fundraising and logistic committees for the Olympia Dragon Boat Club and assisting with boat transport during the annual festival. Next, participating in the Peace Choir and Heart Sparkle Players in the Thunders, which is an inclusive theatrical organization.
So Ms. Caragino, I want to just kind of focus the response here. What's because I appreciate you putting this together, and I do recall pretty robust description of Nicholas's involvement in the community at the earlier hearing. I don't want to skip over that, but I do want to make sure we're focused on here. The reason for the request for the expansion is pretty specific in the request here, so I want to make sure we're addressing that a little bit more clearly, and that is allegations that that Nicholas is walking in the nearby alley between Water and Columbia.
He is not doing that.
I've not been doing that.
Okay, and
Let's
then
get in town for
all right, hang on. So there's that, and if you want to respond to that, that's fine. But just so we have them all out on the table here, it's
I feel like
that alleyway, and then hang on, and then we want to get all the allegations out there, and then I'll give you a chance to respond. But I want to focus on those specific allegations. Again, walking the nearby alley between Water and Columbia, and
that what are the allegations that he's done that since the protection order has been put on him, or is this just something?
Look at the same request here that you guys are, and then standing, it says standing at the corner of the Supreme Court looking into petitioner's workplace.
None of those things. He's not doing any of those things. He's been down there twice.
Your Honor, can I have a moment with you then? This is Jeff Sergino,
Can I come
Nick's
back?
dad.
Okay, thank you. Sure, and
Can we go
make
back
sure
to
you
where the police came? I could go to there.
That's what I'm.
really do one at a time here, okay?
Okay.
All right, we're able to do multiple people, but we need to make sure the record stays clear.
Okay.
So just stick
you.
with Jan until she's ready to move on. Sounds like she's asking for a little more time.
I'm also have
Okay,
disabilities.
Nick. I don't even know where I am now.
You can't read that whole thing.
Okay, so what should I read here? Okay, so
Referring to the distance in the buildings.
The distance. Expanding the restriction to 400 feet would
significantly impede Nicholas's ability to access his community, visit family, and maintain his daily routines.
disability.
Well, I think maybe while you're kind of getting your thoughts organized there, Mr. McDonald, that would be a good clarifying question. Is it, is the allegations that Nicholas Sergino is doing these things, or that he's capable of doing these things given what the restriction in the petition?
Your Honor, I appreciate the clarification. It is not that he has done it, but that he's given the opportunity to do it. If that's not dealt with, because he had done it in the past. We do have evidence that he did go around the Supreme Court building. We have cameras from the state capitol that were presented to me. So I do have that, but this is all, if you look at the comment I made, it says prevents the respondent from, because he can stand in the, as he had done in the past,
Right.
before the order. Thank you,
Okay.
sir.
All right, thank you. And then what was the cause? So had you contacted law enforcement since the full order went
3
into
times,
effect?
yeah.
Okay. What was the cause for each of those contacts?
He was on my neighbor's lot on Water, and he was looking at my house, yelling loudly, and then he walked over into the Capitol campus. The next night, on Saturday night, he was over at my neighbor's house again, yelling loudly, and his mother came, appeared, got him to at least stop yelling. He stayed there for a little while longer, but he was less than about 120 feet from the back of my house, and he was in the middle of my neighbor's lot. So those were the two big incidents. The one at the Capitol was clearly, I walked around the building, and the State Patrol presented me probably 20 pictures of him violating the order. And I said, well, that's when they said it's kind of tied in with the City of Olympia's order that was done earlier. So they didn't see a reason to pursue it.
Okay. All right. So what I'm thinking here is, with the clarification here that the 250 feet extends from Mr. McDonald's property line. And so that's the 250 feet around his property line. That's the buffer in which Nicholas is not allowed to come within or knowingly remain within. In the 200, and that also expands around Mr. McDonald's workplace, in the legislative building there. Now, to the extent, and this is where the property lines of where that building ends, where the Supreme Court begins. I'm not sure what those lines are necessarily. If walking around the Supreme Court building comes within that 250 feet boundary around the workplace. But
Do you have a map? Did you have?
yeah, I've got, yeah. But I think at the same time, around the Capitol building, again, if there's allegations that there's kind of the opportunity for Mr. Sergino, again, the opportunity to kind of stand at the Supreme Court building and watch Mr. McDonald at his workplace, that's not, that's getting more into allegations of stalking, not the restraint, not the restraint provision aspect. So I think there's protection there to guard against that type of behavior. So all that said, I think what I'm going to do is leave the order in place as it is. I think the clarifications today maybe kind of help folks. I appreciate everyone. It sounds like you got some folks there to speak on Mr. Sergino's behalf. We're not going to make any changes to the order today, so we'll leave that 250 in effect, with the understanding, hopefully it's clear, that 250 feet it extends from property line boundaries. So that's the end of the property line of Mr. McDonald's home plot there, the lot lines, as well as the lot lines around the legislative building. And then also, pay attention to those, there's also the stalking provisions in there as well that exists irrespective of the distance location. And so just be aware of all that. But so for the Serginos, they're not making any changes to the order. So it's just going to stay as is. And so we're not going to expand that out any further. Do you have any questions?
Your Honor, this is Jeff Sergino again. Can I say something for a moment here? Now, on the 6.
Well, do you have questions? Because again, I don't want to go into
one question. I appreciate you keeping order the same. Now, are we going to go through this again? Because Nick has been doing a great job. I measured everything out. I have him on a particular route to keep him beyond all of even the 250 range. So even on that corner where he was standing, that is 301 feet from the house. And I measured it all out. So anyway, I appreciate it. We're going to keep him on task. And
He's,
number two, he cannot, if you're down at the Capitol campus, you can't look through the buildings. Those buildings, I mean, you'd have to have supervision.
Fine, and it sounds like there's not an allegation of that happening.
No.
It's more of a concern of being a potential. So yeah, that's fine. Just
I appreciate it.
think that issue was addressed too through that stock, the no stalking provision.
And my name's Nicholas Irritato,
Nick,
and we were gone at Freeze Lake.
All right, thanks,
yes,
Nick.
yeah, some of the times that Mr. McDonald is saying that Nicholas violated these things.
All right, so I understand
well,
people want to be heard. We're gonna keep it
Okay.
succinct though. We're not gonna expand today. We're gonna leave it in place. Thank you all for being here.
Thank you so much.
Sounds like we're all on the same page now.
Thank you.
All right.
All right,
Bye-bye.
thank you.
Thank
Thank you,
you.
Mr. McDonald.
Thank you. All right.
Leave it, turn it off.
All right, and that leaves us with the final matter of the day, 26-331. We've got Catherine, is it Plager or Plager? Plager? Plager. All right, you can come have a seat up here. And then we've got Raymond Harrison. All right, come on up, sir. You can come sit in one of the chairs up here. Are there, okay, you've got a cane there. All right. Thank you, sir. Yeah, these are, my understanding is pretty comfortable chairs with some, no, okay. And the reason we need you to come up, sir, too, is just that that red light there is the microphone, so that can pick you up.
That's when it's after.
Yeah.
Did you hear what he said? That's the microphone.
Yeah, so the red light here, sir, that's the microphone. So when I turn over to you for testimony, just make sure you're talking into the red light there. And Mr. Harrison, or maybe your daughters can let me know, are there any hearing impairments I should be aware of? Or we have
He doesn't wear hearing.
okay, we have hearing assisted devices up here needed. Okay. All right. So before we get started on kind of the merits of this case, I'm going to go over a couple preliminary matters. And the first is, so we're here for allegations of unlawful harassment. And the first thing I like to do at these hearings when folks are here for an initial order is to go over the legal definition of unlawful harassment. Because there's, in kind of common everyday parlance, folks use words like harassment and stalking a lot, and it's important to understand what we're talking about is a very specific legal definition that the petitioner, Ms. Plager, needs to meet by what we call a preponderance of the evidence, which is a fancy way of saying kind of more likely than not. So it needs to, that unlawful harassment is occurring, it needs to be shown as more likely than not based on 6 factors. And I'm going to go over those factors now. And I'd ask that folks pay attention to these factors because they're the basis of, questions I'll ask in response. My decisions are based off of, again, whether or not each 6 of these factors are met by preponderance of the evidence. And the first is a knowing and willful course of conduct. And so by that, we mean there's some sort of pattern of behavior, right? Harassment is more than a kind of a one-off situation. It's an ongoing pattern of behavior evidencing a continuation of purpose. So that's factor 1, is there a knowing and willful course of conduct. Number 2, directed at a specific person. Number 3, without any lawful or legitimate purpose. What we mean by this is that, again, things like, was the conduct initiated by the respondent, and after the respondent was given clear notice to stop, did that behavior continue? Does the behavior have the purpose or the effect of interfering with the petitioner's privacy, creating an intimidating, hostile, or offensive living environment? Things like that. So that's whether or not the conduct has a lawful or legitimate purpose. Number 4, the conduct is designed to alarm, annoy, or harass the petitioner, or otherwise be sort of detrimental to the petitioner. Number 5, the conduct would cause a reasonable person to suffer substantial emotional distress. And finally, the sixth factor, that it actually does cause the petitioner substantial emotional distress. So again, it's not just that the petitioner themselves may well feel subjectively distressed, fearful, things of that nature. That also has to be a reasonable response under the law. So those are the six factors of unlawful harassment. So what we'll do first is I'll hear from the petitioner, swear in the petitioner. While the rules of evidence don't apply at these hearings, folks do provide testimony under penalty of perjury. So I'll swear in the petitioner, hear from the petitioner. Then I'll swear in the respondent, hear from the respondent. As you all here in the courtroom earlier, non-parties do have the opportunity to testify if the court finds that their testimony is material and necessary. I know Mr. Harrison's daughters provided some written materials in the file, and so we can address that if you'd like to testify. And then I'll make a decision, again, based on those factors. Some things to keep in mind, particularly when folks are physically present in the courtroom, is make sure to address me, not each other. These are inherently adversarial proceedings. And so it's important to make sure that all comments are directed up at me and not towards each other, because these can get uncomfortable, and folks will hear things from the other side that they don't agree with, that make them angry. You'll want to respond right away. Just know you'll have a chance to respond. Each side gets a chance to talk, and so just let the other side say their piece, and then direct comments towards me. What we'll do before I swear folks in is I'd like to go over the gist of the allegations and the response, so that way everyone knows what I've reviewed and kind of where I'm coming from. It gives you a chance to address any concerns that I raise right off the top. These are informal hearings, as you may have kind of seen there. I like to keep these sort of back and forth. Again, I've read everything, so there's no need to sort of read what you submitted kind of verbatim. I like these to be a bit more back and forth. I'll have questions for you, things of that nature. So I think given that, it's helpful for you to know where I'm coming from. All right. So according to Miss Plager or Plager?
Plager.
I'm sorry, Plager. All right. She's alleged that Mr. Harrison, who lives in her building, has made her uncomfortable through a series of interactions. What I'm focused on is in Miss Plager's petition, I believe it was on June 8th, she received some advice from a friend that if you set clear boundaries with Mr. Harrison about what's making you feel uncomfortable, then he'll likely stop. The police, Miss Plager did call the police after the last incident here. And in that police report, it notes the reporting party, so Miss Plager, went on to tell Mr. Harrison this is the incident outside the elevator, leave her alone, but stated the male started laughing about how she was startled and how she was holding her left hand. Miss Plager, reporting party, stated this was infuriating, so she walked away. Miss Plager is concerned that the man may become violent due to his impulsiveness. Miss Plager also states that nobody in the building likes him and he makes other women and men uncomfortable with his presence. She stated the male has never threatened her or been aggressive towards her. She states the male's actions are alarming due to the strangeness. And the exhibits provided, in the exhibits in response provided by Mr. Harrison's daughters, I believe, and this is where you can correct me if I'm wrong, try to explain that kind of odd behavior, strange behavior, is not meant to no harm is intended there. There's just some maybe oddities of behavior that are being misinterpreted, things of that nature. And so my concern off the bat for the petitioner, so something you may want to address, is as I went through the elements there, a lot of times these types of allegations, they really hinge on that factor of there's no legitimate purpose. And by that, I mean, there's uncomfortable interactions every day, and some make people feel very uncomfortable. And the unlawful harassment law, before the courts get involved, it does require the recipient of that behavior to sort of clearly communicate that, this is making me uncomfortable. I don't want this anymore. Please stop. And then if that behavior continues, that's when we go, okay, well, maybe the courts can get involved here. From my review of the petition, it sounds like, again, I don't have the exact date in front of me. I believe it was about June 8th. Maybe it was July 8th. But that last incident, there was a clear message to Mr. Harrison that you felt uncomfortable and you wanted that behavior to stop. You felt that his reaction to that was, according to the police, infuriating, and that you then left. And I believe you've been staying somewhere else in the meantime.
Yes.
And so, but have nevertheless not had any contact with Mr. Harrison since. So as you go through your allegations, you don't have to confine your comments just to that. But that's something that is in my mind is a concern as far as granting an order, is that it sounds like you did clearly communicate on advice of some friends for whom this may have worked in the past to set some boundaries. You did. And then we don't really know, Mr. Harrison hasn't really had an opportunity to follow those boundaries or not at this point. So that's where I'm at this point. With that said, Ms. Plager, I'll swear you in and then hear your testimony.
Want me to stand up?
You can stay seated, that's fine. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Okay, go right ahead.
Thank you, Your Honor. My name is Catherine Naomi Plager. I've been in the building 5.5 years. I've never experienced feeling threatened in this manner. I have a master's in clinical psychology and a background in bachelor's of social work from the University of Washington. So observing people's behavior is just kind of second nature for me, but I've never thought I would ever receive, being targeted and followed repeatedly and feeling so threatened that I left my building for 4 weeks. So I wanted to say that. I am also citing 3 Lacey police reports, and I will present a detailed chronological account of incidents and approximate times. I don't remember the exact times, and certainly the location was either the parking lot, the side of the building, or inside the building in the main area. I will demonstrate the respondent. He had persistent, non-consensual, unwanted behaviors that escalated very quickly over a 1-month period of time. That frightened me, that it happened so fast. So from June 25th to July 23rd, I stayed away from the building, and I may have come back a couple of days to, like water my plants and take care of my apartment. But I went out of my way to avoid contact with the respondent. I didn't park in the parking lot again. I took other entrances into the building other than the main entrance. It appeared that the respondent seemed to know when I was in the main area, when I went through the kitchen area and through the main door. So I stopped using those doors. So needless to say, this caused me severe emotional distress. That repeated a course of conduct that continued to, I feel that he intended to frighten me, and I was fearful for my physical safety. And I'm not a person who's terribly afraid. I worked for CPS down in Oakland, California, and I have never been so afraid for people, for my safety as in this building. So I had clients in Oakland, California that weren't very happy with me, and I still went into those neighborhoods and I still conducted myself in a professional manner, and I was never accosted or anything like that. But I'm just saying, I'm not here because I don't have anything else to do. I'm here because I would like to be left alone. I would like to find a way to have a number, 250 to 500 feet distance. I did bring in a picture of the outside of the building so you could see that there are two different courtyards. We live in opposite courtyards, and there is a couple of main areas. And I stopped going into those areas because of being stalked. So I'm going to begin with a short description on May 31st when I recognized that the respondent was engaging in stalking behavior. I was at an outdoor memorial outside on the lawn on the side of the building where a woman was killed in my building by a truck who crashed into the building on a few days before the 31st of May. So we had an outdoor vigil on May 31st, and many of us were standing outside waiting for it to begin. And I remember specifically, I was talking to a group of friends, and then the chief of police was there, and we were all talking together. And then next thing I know, I look up and there's the respondent looking at me. He's like way over, like 30 feet away. And then I go, ooh, that didn't feel very good. It kind of made my stomach queasy. And I looked away. And then again, I looked up, and the respondent was staring again at me. He was 20 feet, he was like 20 feet away. And I thought, oh God, I'm feeling really uncomfortable with his looking at me like that. I looked away, talking back to my friends. And the next thing I know, I look up, he's staring at me again, and he's 10 feet away. And I'm going, that's when I knew that there was a problem, because I was trying to deny it. I had seen him in the hall, the downstairs area a number of times. I never made eye contact with him. As a number of my friends, we don't make eye contact with him. I don't really need to know and speak to everybody in the building, but especially I didn't want contact with him. And then on bingo, the following Friday night on June 5th, I was down at bingo at like 5:30. I usually bring food down for the people, and I say hi to everybody. And I was talking to a friend of mine, and next thing I know, I look up and I see him staring at me from across the room. And I like look down, and then I look up again, and he's still there. And I look up a few times, and then I told my friend, look, here it is, this is happening again. And so we just kind of stayed there, kind of looking at him and looking away, looking at him, looking when he finally left the room. Now, I never went to another bingo. I stopped going to bingo because of that. And so when I returned to my apartment last Thursday, I went to bingo because I wanted to talk with the three men running the bingo, and they had talked to me, and they were concerned for my safety. And they said, well, you don't have to worry anymore because he's been banned from bingo. And I said, oh, I didn't know what happened. Well, we had words, there were words, and he can no longer come back into that room during the bingo. So I could conceivably go back to that activity. On or around June 8th, on Monday, I believe that's when I was walking down the hall, and the elevator opened, and the respondent came out of the elevator, and I was a little surprised. And that's when I told him, I don't want any contact. I don't want you to talk to me. I don't want you to approach me. I don't want you to stare at me. When you see me, turn around and walk the other way. And what he did, I felt like, I kept backing up because he kept like coming forward, like I felt a little threatened about that. And he laughed in my face the entire time I spoke, which was under a minute. And I didn't realize I was going like this with my finger. I don't want you to talk, and he did the same thing. He took his hand, he went like this, and he just kept laughing. And I'm going, oh my God, this is a big red flag. I'm not going to get anywhere here. I am definitely unsafe. I turned around and I walked away. Then the next time that I remember something big happened, on Friday, June 12th, I turned into the parking lot. I parked my car 2 lanes from the main building. And within like 40 seconds, the respondent turned in. There's like 3 entrances to the parking lot, and I took the first one. Well, he turned in on the third one, and I saw his car, and I'm going, oh God, it's that guy again, it's the respondent. And he parked in front of a business, which is where we are not supposed to park. So he parked there, he gets out of his car and he comes towards my car and I'm feeling immediately threatened. He's walking towards me and I walk towards the back of the parking lot where I see a friend sitting. He's having a cigarette outside and I thought I could feel safe there. So I sat down. And the respondent like kind of hid behind the cars as he got closer and closer to where I was sitting on the bench with my friend. And then he got closer and closer until he could hear the conversation. And then he started to involve himself in the conversation, which had nothing to do with him. And after like a minute, I got up and walked into the building and he didn't follow. I was grateful that he did not follow me. And I started to, I did find out that he had done a stalking behavior with one of my friends in the building, and evidently she was able to stop it. And so he never did it again to her. And so I know about that. And then I had a good friend of mine come and stay with me during the day on June 15th and 16th. And we went into the Lacey Police Department. And I found out that we had to wait for the officer to call me back. So we waited outside and he called me back and I finally filed a report. I've never been stalked before. So well, is this really happening? And I was so uncomfortable. I wasn't sleeping well. I wasn't eating well. I was very nervous during that period of time. So the respondent left me alone because he saw me walking outside with my friend, so he didn't approach me. And then on June 18th, on a Thursday, I was downstairs in the main building talking to 3 friends, and we were behind a partition. There's a huge room, about 120 feet. There's a kitchen in the middle. And we were sitting on the left side of the kitchen behind a partial partition talking. And one of my friends said, "What's all that noise in the kitchen?" And she said, "Go check it out." So I checked it out and there was Raymond. And I thought, oh my God. So I turned around and started walking away. Well, he started walking towards me very quickly. And of course I felt threatened about that. And then I went back in and sat down by my friends, and he didn't know that my friends were sitting there with me. And so he ends up walking past us and he goes into the bathroom at the end of the the big hall. And he stays in there for like 45 seconds. And then he opens the door and he goes across. There's like 2 feet across. And there's another bathroom there that says, no entrance. I'm sure it's for staff. And he goes in there and he's in there for like a couple of minutes. And my friend turns to me and she said, I wonder how he knows you're downstairs. And I said, yeah, that's a good question. She goes, I think you should leave now. So she said, run out of here now. So I ran through that big hallway and out to my car, feeling threatened and unsafe. On the 24th of June, I was getting ready to leave to go and stay with some friends. And a friend of mine had walked me down to the car, and we stood by my car talking. And then I noticed that the respondent was over 1 lane over, right directly in front of away from me, but directly in front of the building, going very slowly in his car. It took like at least 5 minutes for him to get by, because I had to go back into the building and to get some more things before I left for a week. So I felt really threatened about that. And there was another time, which I didn't write down, where I went out the back door and I started walking across the asphalt towards where the shopping little area is. And he turned the corner and was in his car, where he was moving very, very slowly, going straight. And he passed me and still going really, really, really slow. And I just felt very uncomfortable with that. It made me sick to my stomach. And so that happened. So I did leave the building on the 24th of June. I left for 6 days. I came back. I spent 1 night. I packed my bags and I was gone for the next 3 weeks. I wouldn't have done that if I felt safe. I'm not a person who is easily threatened because I feel like I can hold my own. If I work for CPS and work with people who are threatening me, I could still hold my own. Okay, so I cited the Lacey police, 3 police reports. I went through the several times I felt threatened. And let me see. Yeah, I have never thought I would ever need to ask for a protection order, but I feel a great, since I've been home 4 or 5 days, I'm not sleeping well again, just because I know I have to go out other doors. I never go to the front door. I know he's going to see me down there. I don't know how he knows when I go into that area, but he does find a way to kind of surveil me, to monitor me, to follow me, to try to speak to me. And even after I said, please, no more contact. So I'm asking the court today for a minimum of a 250 to 500 feet, a protection order. And there's a picture here of the 2 courtyards that, and there have been several protection orders that people have granted, the judges have granted in this building. It's not like a small building at all. And yeah, I'm just, thank you.
All right, so before turning it over to Mr. Harrison, so a couple of follow-ups, because I think I may have kind of misstated some things there at the beginning, which is why I'm glad I let folks address my concern. So the elevator incident, June 8th, that's when you would communicate.
Approximately, yeah.
Approximately.
I wasn't quite sure of that date.
Okay, but
I knew it
around
was-
June 8th, that's when you had said, I feel uncomfortable, please cease this behavior. And it sounded like since then there'd been a handful of allegations of
Yes.
continued conduct since
Yes,
then. Okay, all right. Okay, specifically that, again, approximately, but June 18th, June 24th.
An officer, Your Honor, can I say one thing?
Sure.
I forgot to say. So my experience of the respondent, I've never seen him with a cane. He's always been able-bodied. And so when he came at me, he seemed very able-bodied, and walking without a cane. So I don't know what happened between then and now. So I'm saying that I'm concerned that there's this appearance with a cane, and maybe he needs it right now. I don't know. But during that period of time, I've never seen him crippled or walk with, he's always been very active.
Okay. All right. Thank you, Ms. Plager. All right. So Mr. Harrison, I'm going to turn to you next. Your daughters have filed some letters on your behalf. And so I guess I should ask from the start, either one of you wishing to testify as well?
Yes.
Okay. All right. So I'll hear from Mr. Harrison first, and then make a determination on if any non-party testimony seems material and necessary. All right. So Mr. Harrison, are you able to hear me okay?
Speak.
Yeah, I'm going to need to, yeah, we need you to speak yes or no, just so the record can pick you up.
Yes, I can.
Okay. All right. And can you please raise your right hand? Do you swear or affirm the testimony you're about to provide today is the truth and the whole truth?
So help me God.
Okay. All right. So Mr. Harrison, you've heard the allegations there. This is your opportunity to respond. I think, again, I'll give you the benefit of where my head is at. And that is that it sounds like allegations are that this incident when you and Ms. Pager were outside of an elevator, she had expressed to you that she was feeling uncomfortable by some of the behavior, and that there's been some incidences since then that she's saying was a continuation of that type of behavior making her feel uncomfortable. So you're free to provide testimony on whatever you'd like, but that's kind of where my head is at, is sort of trying to understand those incidences subsequent to that notice being given. So go ahead, sir.
I have no feeling at all about anything other than her coming out of the building. I was going to the kids' place. for lunch or something. And she's wagging her finger at me. I said, stop. I don't know. And then she says, I'm wagging her finger. I said, look, I have to go right now. She says, you have to come talk to Nancy. Well, I had no clue. I says, look, I'm late. I'm going to dinner with my kids, my grandkids. I had my food and I just left. I didn't know what was going on. It was spooky. It was frightening. How is my shoes and feet? Both my legs have been broken. I use a cane when needed. I have numerous physical body injuries, car accidents, motorcycle wrecks.
You need to stay in the microphone.
Anyway, I don't know what to say. I'm a happy-go-lucky person. I make people laugh. I've been in theater for half my life here in Yelm. Since 2000, we moved here.
Do you recall any of the interactions raised by Ms. Plager?
Nothing specifically. No, I'm floored. I mean, I drive my car very slow all the time. It's amazing how fast people drive through here. People always yell down, slow down. Well, I idle my car to the store every day down the main walk.
During the incident outside the elevator, because in my mind, that's kind of a critical event here. Because
it's scary. It's
okay.
Frightening to have her yelling and hollering.
Okay, and so regardless of
I had no defense. I had nothing to say.
Okay. Did you it's kind of tone and all that aside, do you agree that the message was conveyed that something you were doing, whether it was willing or not, was making her uncomfortable?
No.
You don't
I mean, I don't know. I had no clue. She wanted me to go talk to Nancy, and
who is Nancy?
I don't know. One of the women. They're all moving too. They're all leaving, apparently.
Okay, so you left that interaction not understanding that she was communicating that she was feeling uncomfortable and wanted you to stop some.
Oh no, it scared the hell out of me. What was going on? I don't know. I have no clue.
All right. I think it would be helpful to hear from your daughters.
Yeah.
They wrote some letters on your behalf that are in the file. And so we've got both of them here today. I haven't, is it to your left there? Is that Sunday? Or is that, okay. So Sunday, if you would like to raise your right hand, and then I'll put you on, then we'll have you spell your name for the record too. So first, do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay. And then if you could please say and spell your name.
My name is Sunday Elder, SUNDAYELDER.
Okay, go ahead, ma'am. Thank you.
I just want to say, we got incomplete records from the police reports. We have page 1 of, I don't know. There's pages 1 of 2 with no 2, and there's a 2 with no 1, but we have 4 different case numbers. 334, 393, 397, and 592. And they're either out of order or also incomplete. So I just want to put that on note.
Okay. And they're the same records the court has. And sometimes these CAB reports, they're not.
I don't know.
Oh, okay. Sorry. Sorry. Yeah, I apologize. I sometimes assume a level of familiarity with this stuff.
No.
So a CAB report. So this is I think what I'm looking at here in the exhibit is when the police respond to a call, they'll have we kind of call these CAD notes, and it's basically a printout of the officer's real-time notes of the incident. Often these are what are relied on when there's no charges filed, no arrests are made. An officer will essentially determine that there's not probable cause for a crime, But nevertheless, that interaction is still recorded
Yeah.
as part of an internally generated case number. And then this report is, I think it's titled a police event number, and then it's on the report there.
Right.
So these are often, they can be a little hard to follow just because these are not officer narratives written under penalty of perjury associated with criminal charges. So that's what you're looking at there.
Sure. I think there might be 4. Anyway, the timelines aren't sequent, anyway, maybe not important, but I wasn't sure if we received all available information. That's just the first statement. I can speak to him feeling threatened in the manner that he is he has expressed to me in beside conversations where I'm not present with her, that he, first of all, doesn't actually really know her name. He has never known what floor she lives. Do you know what floor she lives on? He doesn't know much about her other than she has bullied him, is the context that I have gotten from our interactions. He doesn't think she's going to physically harm him, but she ridicules him in public. And that is a perception of his stories being told to me, his daughter, coming to me. I don't know why this woman keeps bothering me. So that is his version of his experience. I'm not sure what else to say. He's used a mobility device for 40 years of some sort. So that's absurd. And he most often pushes his walker.
And I do have a question about that, because I obviously see him now with the cane or the walker. And the letter indicates that he also, though, is, and this may not be mutually exclusive. I don't do CrossFit, but
yeah,
there's indication that he loves CrossFit.
Absolutely.
So does he have mobility issues, but nonetheless is able to engage in kind of CrossFit workouts and things of that nature?
Correct. Can he speak for himself on that?
Preferably, yeah. Go ahead.
Yeah, I've downloaded both legs. Both legs have been broken, spiral fracture, multiple fractures from hip to knee. I've been through PLP, platelet-rich plasma, with the Veterans Administration. I got hit on a bicycle. They've done my knee, my elbow, my hip. No, my hip is coming up next. On my knee, my foot, and my shoulder. And my shoulder is sort of whacked out now.
Can you tell him how you are involved in CrossFit, please?
How I'm involved. I ride a bicycle normally there.
What do you like about CrossFit?
Well, the camaraderie, the group, it's fun.
So you're able to engage in some level of CrossFit despite some of the injuries you're talking about?
Oh, I have lots of handicaps to boot. I mean, to boot. Yeah, it's really fun.
May I?
Yeah, well, I'd like to hear from both. So you're
I'm
Dawn
confused
Young.
about everything.
Yeah.
Okay, understand, sir. So I'm going to hear from your other daughter here next. So Miss Dawn, I know we've only got 3 chairs, or 2 chairs. And the mic will likely pick you up right there.
I would love to stand for a moment.
It's okay.
That's fine. Yeah, the important thing is mostly that the record gets you, but that will pick you up. All right, so Miss Young, I'll put you under oath and then have you spell your name for the record. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Absolutely.
Okay, go ahead.
All right. Just coming back to.
And if you'd like to just, for the record, we get you on your name. If you could say it and
thank
spell
you.
it, please. Thank you.
My name is Dawn Young, and I am Ray's eldest daughter. I would like to just follow up on the CrossFit. That part of what is so special about that CrossFit community is that they do They are very aware of him. It's been over 10 years that he's been participating with the Woo Dogs in Yelm, and make concessions and help him still exercise. Physical activity is extremely important for my dad. He has arthritis throughout his entire body. And as he mentioned, severe injuries that have been, essentially our whole life, and PTSD from his service in the Air Force during the Vietnam War. He has had multiple injuries since then, brain from falling on his bike, and a lot of trauma. And the community there includes him and involves him. He is an Eagle Scout through and through. And the CrossFit community allows him to do the community cleanups and exercise to the best of his ability. He can still do pull-ups and chin-ups as long as his shoulders are there. He doesn't run or do, a lot of the exercises that they do. So they have modifications for his condition.
Okay, thank you. I appreciate that. That's helpful context. Okay, so I want to stay on the allegations here a bit too,
Yes.
and then it's because it's Miss Plager's petition, so she also gets an opportunity to sort of get in the last word. And before I'll go back to Miss Plager, I want to give you a chance, and all of you a chance to address kind of what I'm zeroing in on, which is there seems to be a huge disconnect that I want to know a little bit more about between, Miss Plager, I think it's clear, is demonstrating some significant distress based on some of these interactions, to the point where she moved out of her apartment. These are apartments.
Yes.
Was feeling unsafe, wanting to be around friends. In her mind, at least, gave extremely clear direction to Mr. Harrison that she was feeling uncomfortable. It called the police a couple of times, and the response, and I'm not saying it's false or anything, but the response is sort of like, I didn't know, or I don't know what she was talking about. And so if you can help me sort of understand where that disconnect may have come from, because it sounds like there's been more than one interactions since that elevator incident where at least Miss Plager indicated she felt uncomfortable, and so I'm having a hard time squaring what on one hand is allegations of pretty clear notice being given, and on the other hand, sort of a confusion of like, I don't even know this woman. So that's kind of what I want to hear both sides from. And since we're on Mr. Harrison, I'll let you kind of go first. If you want to address, you and your daughters want to sort of address where that miscommunication may have come from.
More than one woman has come up and said, be careful of this girl. She's out to get you. Another woman apparently has warned me that she was in the bingo parlor the last time, and to stay away. Okay, well, then another person comes up and says, well, I don't know what's going on. I've been feeding their cats for like the last week and a half, and she's supposed to be back and she's not here, and I don't know what I don't know. People are saying, just stay away. I don't know.
But if if people are saying stay away from her, it sounds like what she's saying is there's been some incidences where she's perceived that you've been approaching her.
I don't think I've ever approached her.
So
No.
may I at this time, that was our first question as his daughters, be like, who is this woman and what's been going on? And he again is like, I don't know. He first brought her up as the woman with a red beret to us. He said, there's this woman with a red beret who really just doesn't seem to like me. And he had people from the community tell him, hey, watch out, she's out to get you. And he's like, well, why would anybody be out to get me? And that, asking for his name, asking for information about him, asking what he does and and who he is and where he's going. So she was pursuing him aggressively, where he is oblivious to who she is and what she's doing. So they have a community, and they have community activities that are there for the entire community, all of the residents, whether it's bingo or the soup, moments. And and speaking directly to the memorial, that was deeply traumatic for everyone. And we know that family. So for him to be there was certainly not out of the question. And if he is perceived as staring, he does look into the distance quite often. And part of that is when he is doing his best to be calm and not be extremely emotional. So there is a staring element that is a part of his calming. And if you could hold that.
Yeah, I'm like on that
thought. May she interject at this moment?
Well, sure. Well, I will,
Because
again, it's helpful for the record. Maybe we'll stick with Dawn until you're done, and then we'll move over
all right.
To Sunday, and then we'll turn it back over to
another aspect of this is like he doesn't know where she lives in the building or anything like that. But what he does hear is other people coming to him to warn him that there is imminent danger. And that makes a person extremely uncomfortable and feel unsafe in their home, which leads to him losing even more weight, not being able to hold his own food, spending extra time on the toilet. And and the fact that she's never seen him with a walker blows my mind, because my son and my husband go swimming months ago before their pool, and he always has his walker.
All right, and I don't mean to cut you off, Ms. Young. I think I'm starting to understand, I think, the nature of your testimony. I will hear from each of you once more.
Okay.
I'll want to hear from Mr. Harrison last, so I'll turn over to I'm sorry, it's Sunday. I can't.
Sunday Elder.
Elder, yes, Miss Elder, go ahead.
So as to why he is where he is, he's doing his regular routine, normal business. He's parking cars, he's in crowds. I did note, like, the police chief probably would have been of interest to him. He is extremely friendly with law enforcement. He never avoids them, and he would have been seeking out the attention of that police chief in that crowd. If she was speaking with the police chief, I believe there's a very reasonable explanation for why he would be looking in that direction.
Mm-hmm.
He actively pursues, good relationships, fosters good relationships with law enforcement. So I could see that in that interpretation, why she would, I do understand and respect that she doesn't feel safe, that whatever is happening, her reality is that he is in her space and doesn't belong there. That is her reality. So I do respect that, but he has every right to be in all of these places, the community kitchen, community bathroom. I don't know why he would go into a restroom for 45 seconds, but maybe it was out of toilet paper and it was looking in the other one. There's probably a very community focused reason why he would be in and out of restrooms. Other than that,
Thank
as
you.
far as looking, like, why in the crowd, that was something
Sure.
I did want to address specifically. That's who he would be looking for in that crowd.
All right, thank you, Ms. Elder. All right, Mr. Harrison, if there's anything further you'd like to say, I'm going to turn it over to Ms. Plager for some final testimony, but you'll have a chance to any further.
Sad what's going on. Emotionally, physically, it's not hasn't been easy. Pray for this family, for this lady. That's my hope and prayer, is that something can annually come about, some form of communication. I don't know. If I can't look, if I can't smile, if I can't.
What have you done since you were served the papers? How have you been in the building? since the day you received this packet? What does your life look like? He's actively evading the elevator. He's been using the stairs and he's actually.
I've been
furthered
using the
injuries.
stairs a lot, so maybe that's why my hip's a little bit more out here.
All right.
But I have avoided using the stairs to a degree. I do have a cane not the cane, but the walker. I have blankets that I carry. I have cushions that I carry around.
All right.
To go out to smoke. I pick up cigarette butts. I break down boxes all over the place just to pick things up. And
All right.
it's just strange. I mean, I feel like I'm in a different space. I'm not in the same frequency for some reason.
All right. Thank you,
Pray a
Mr.
lot. I concern my physically body is in pain constantly.
Okay. All right. Thank you. Thank you, Mr. Harrison. I appreciate all the three of you being here and providing testimony. I'm going to turn back to Ms. Plager. Ms. Plager, I did allow Mr. Harrison to have some folks speak on his behalf. I see you're here with someone else. Is this individual witnessed any of the events?
No.
Anything in that?
He's a friend of mine.
A friend. Okay. All right.
Support.
All right. Support. Okay. All right. Well, Ms. Plager, you've kind of heard the response there. This is your petition. You have the burden of proof.
Yes.
So you're also entitled to sort of the last word.
Thank you.
So I'll give you a few moments here as well.
Thank you, Your Honor. So,
And if I may too, just because again, these are dynamic proceedings. And so one thing that is in my head now as you conclude is you're clearly shaken.
Yes.
I don't think anyone's questioning that. One thing you may want to address is, cane or not, just having the opportunity to have observed Mr. Harrison, and then the collection of incidences, even before and after this elevator interaction. To me, the way they're written, it suggests what in your mind is clearly someone stalking and all of that. Looking at it not through your eyes could also be pretty innocuous. But it is, somebody who's in CPS in Oakland, somebody who's clearly very shaken. One thing that I'm struggling with a little bit that you may want to address is based on the incidents you put in your petition, something has really shaken you.
yes.
And I'm still having trouble sort of understanding kind of what that is.
Okay.
Taken as a whole, I can understand how innocuous events and siloed as a collection can be something much more traumatic. But even still, the kind of walking up, kind of at some group settings, maybe there's some staring going on, making you uncomfortable. Maybe, sounds like he was also getting closer to you at some of these incidences. There's obviously this kind of heated incident outside the elevator. But if you might want to address, like, what is it that is there something I'm missing that is causing this substantial, again, I believe you feel substantial emotional distress here. And so given your background, too, I'm just, if you could address that too, I think that would be helpful.
Why I'm feeling so much distress?
Yeah, based on the types of incidences you're saying happened in the petition, is it the collection of all of those together? Like, what is it that is causing this level?
It's the consistency of the patterns of behavior.
Okay.
Consistently following me, having turned into the parking lot right after I did and pulled up into a parking spot very close to me. He gets out of his car. He didn't use a cane. He didn't use a pusher. And he walked right up to my car. And that felt intimidating. He walked across the whole entire parking lot where I was sitting with my friend. And then in the kitchen on the 18th of June, I went in the kitchen to see what all the noise was for my friend, and he didn't have a cane, he didn't have a pusher or walker, and he comes walking very fast after me on my heels practically. I had to walk so fast. And so how he presents himself in the building is different than what he presents himself today. So that's one thing. And the thing that makes it so dangerous for me and my physical safety is I can't get him to stop. I can't get him to stop. I have been told not to have any contact with him, not to show, any emotion. and, just to avoid him. And even calling the police, there's no protection. I have no protection. And that's the main part of it. He can continue to secretly, do what he's doing. Maybe he's deterred somewhat by coming to court and by me asking for a protection order. I didn't know his last name. Many of us don't know each other's last names in the building. I didn't know what room he was in. I tried to find out because I tried to file a protection order, because that's what the police department told me to do repeatedly. I recommend that you file a protection order. I couldn't do it. I even tried to take the paperwork up here and they said, I'm sorry, you have to have a last name. And that makes sense. So I had to hire somebody to do that. And I got that information. And then I was able to at least get a court date and then come in here today. So that's why I was asking, like, does anybody know, like, I can't protect myself and I should have a right to do that. I'm 71 years old. And here I am needing to defend myself in my apartment building. I've been in for 5.5 years and feeling really distressed. Like I said, I used to go to parts in Oakland, seeing clients that nobody goes to. And even the clients themselves, they said, where are you going next? And they'll say, please don't go to there. You're going to get shot. All white people get shot. I went there anyway because I had a child there. And I had to be with my energy, and I had people come up to my car, and I rolled down my window and I started smiling. So I know how to handle myself with people. I know how to handle adversarial things, but I cannot protect myself. If someone is secret, that's the nature of stalking. They don't want other people to know that they have this behavioral quirk. And it's embarrassing. And I can see why they would want to, represent themselves in a way that I don't see them being in the apartment building. Like I said, in the elevator, there are 4 elevators in the building. So he could take any other elevator, and I never take that elevator. Since this started, I never take the elevator that he takes.
All right.
And the whole thing about when I set the boundary, my friends told me, 3 or 4 women friends said, you have to set a limit. You have to raise your voice. You have to let him know you don't like this. And one of the women said that he had done that to her, and she raised her voice, and he stopped doing that behavior towards her. That's what she told me. And so when the elevator opened and I was walking by, and he was right here, I was surprised, and they said, raise your voice because you are too nice. And I go, well, I'm just restrained. I'm careful with my words because words can cause a lot of harm. And, but I had to set that boundary, and I'm really glad I did. And there are a lot, and I have witnesses, but they are afraid for their own safety. They didn't want to write a statement because they live in the building and they have to be living with this man in the building. And I totally respect that. There's like four people like that. I could have had 4 witnesses, and I didn't want to put them at risk.
Excuse me, Your Honor.
I think, hang on.
We had a neighbor provide a statement.
All right, thank you. Hang on. All right. All right. Well, Ms. Plager, this is probably not going to help your faith in the system then. I don't have grounds to grant an order today. The reason being is, to me, this is 50-50. I don't know what's going on here. And you've got the burden of proof to make it more likely than not that what's being alleged. I think if everything you're alleging is true, you are probably entitled to an order. But there's such a gap here between the allegations and the response, and frankly, and the types of allegations. Again, it's a series of what could either be innocuous behavior, or it could be something more serious than that. And when you're faced with that situation, and there's not something to push it over the edge of, it's more likely than not, by law, I can't grant the order. Now you say that but I'll say a couple of things. Number one, it sounds like maybe the elevator interaction, at least according to Mr. Harrison, was something he didn't understand or what didn't get. Whether or not that's true, in these types of situations where it's, allegations are strong, but they just don't kind of cross the threshold into getting an order. One thing I like to tell folks is, at this point, Mr. Harrison, I hope the message has been communicated that Miss Plager feels very uncomfortable by certain behaviors. Doesn't sound like she's out. She's, to the extent you're hearing, she's out to get you. Clear notice has been given. I'll say that she's feeling uncomfortable to the extent that she's called the police. She's filed this protection order. I'm not granting it. I don't think there's sufficient evidence to grant it, but I do think that the message should hopefully be clear at this point. We need more than what's in the petition, and that could be testimony from other people. It could be any kind of evidence, but without that, given what's in the petition and given the testimony I'm hearing today, I just by law can't grant the order. Clear notice, I think, has been given at this point. There's been a whole hearing on it, a lengthy hearing with lots of testimony. So I hope that's clear at this point going forward. Not going to issue the order today, though, but I think that at least has been established. And with that, hopefully everyone's clear about, what's at least being received and how things are being interpreted, and folks can address behavior accordingly. But again, not going to issue an order. So there's no restrictions on your behavior, sir, by law, other than just keep that in mind, how that behavior is being received by Miss Plager.
Yes, sir.
Do you have any questions?
May I? Because I really strongly feel that my dad brought this up. Communication is really important, and especially for a woman who has an entire background.
Sure, but let me
degree.
start you. If Miss Plager doesn't want to engage and doesn't want that amicable relationship, that's her right. She doesn't have to have it. And so that just needs to be respected. And hopefully it's been communicated that she just doesn't want that.
Ma'am, I have a question. May I, or does Ms. Plager have access to read our statements, and can I offer them to her?
Everyone, all the statements that are in the file, everyone has access to that. Yeah, that's once they're in the file, they're there for everyone to see. That's why we can all see everything. Yeah, so that's all in there. That's right.
Please read them.
So, but yeah, it's, even if you really want to have an amicable relationship, that hopefully it's clear that she's not interested in that. So let's just, I think it's a situation where you just have to go your separate ways.
Walk away.
Never help anyone again.
Interest her in a mediation, at least to partition the building and avoid certain elevators, or just do all, should we all avoid her completely? Or
I'm not going to start giving legal advice about how to enter. There's no orders.
Okay.
I think Ms. Plager expressed how she's felt. I would leave it.
Thank you.
Hopefully we'll be peace.
Thank you, Your Honor.
Thank you all. Yeah.
Peace. We're at peace.
Any other questions?
We're at peace.
I don't know if I could answer that question, sir.
Yeah.
But no orders are being issued today. So I'll say that.
Thank you.
All right. Thank you all. And then. Yes, everyone's dismissed. Thank you.
Oh, thank you
Yes.
so much.
Thank you, Your Honor.
Thank you all.
Thank you
Have a
very
good rest of your week.
In his name. Okay.
Mr. Baca, I think everyone else on here is Mr. Patterson's. Do you agree?
I'm pretty sure, Your Honor, that is correct.
Okay.
Your Honor, I'm pro se.
Oh,
What's your name?
LaCamera.
Brian.
Brian LaCamera, Your Honor.
Cameron?
I
Okay.
fired Mr. Patterson.
You don't fire a court-appointed attorney. You ask to have him replaced, and if I agree, I would. do so.
Representing myself pro se, Your Honor.
Good.
Well, did you apply and get Mr. Patterson appointed, or did you hire him?
He was appointed.
Well, you'll wait for him. He is still your attorney. If I make an appointment, you don't fire him. You come
Well, I
back to
asked
me.
him to withdraw. I should.
Okay, just stop and wait until we get your attorney of record back here.
Honor, I'm pro se.
I called you, Mick White, and you didn't answer.
I am so sorry. I was in the waiting room and was having issues trying to get in.
She was trying to get you to respond so she'd know you were who you said you are, but you didn't. So
Yes,
anyway,
ma'am.
here we are.
So sorry.
We're back on the record in BU 2025 TR 1169, State of Kansas versus Leah, is it Lee or Leah?
Leah.
Leah A. White. Jared Regier appearing for the state. The defendant, Leah A. White, Leah Ann White, now appearing in person and pro se. Ms. White, you have one count of driving without proof of liability insurance. You failed to appear when I called your name today.
And Judge, I'm sorry, I was in a breakout room with something labeled Andrew Elam, but he never came on. So maybe it's a different one now. I still need a breakout room with Andrew Elam.
All right, Mr. Elam, as I said a while ago, there will be some typing appear on your screen and it'll say something about the clerk is inviting you to a breakout room or something of that sort. Did you see it? When you see that, click on it. And Mr. Patterson, you're gonna have to get him to turn his volume on when you get him.
You just need him to click on join. There he goes. Okay, thank
All right, now. Okay, Miss White, we're back on 25 TR 1169, State versus Leah White. When you were here February 18th of 2026, you said you wanted to apply for court-appointed attorney and or diversion.
Yes, ma'am.
So at your request, we set the matter over to May 11th of 26. You were still pro se. You had the matter set over to July 27th. The state objected. You said you were going to apply for diversion. So I continued your bond till today. I noted that it has taken 6 years to fight to try to resolve this case, and I'm still not there. I issued a bond forfeiture, a bench warrant, and a no bond hold. So at this point, your status is to turn yourself into the sheriff. And where are you? What town are you in?
I'm in Sedgwick.
The town of Sedgwick or the county of Sedgwick?
Oh, sorry. Sedgwick County.
Where in Sedgwick County? What town or area are you in? Wichita or where?
Outside of Wichita, close to Derby.
Okay. Why weren't you here when you were supposed to be?
Ma'am, unfortunately, I had gotten up and was ready to go, and I had to take care of my granddad at that time. And then unfortunately, when I called and talked to him, I had fallen back asleep. And then I woke up a few minutes later and it was past time to get in. So I got in as soon as I could. And then I had called the Butler County Court Department and told them, hey, I'm in the
I don't
waiting
want to
room.
know what you did afterwards unless it has, I just want to know why you weren't here. So
yes,
you
ma'am.
fell
And I
asleep.
did.
You
So
fell asleep.
I had to call the courthouse twice because one lady said that you guys would pull me in as
All right,
as
but you
soon
basically you weren't here. Basically, you weren't here because you fell asleep. And now are you
on
trying to
time.
blame it
Yes,
on?
ma'am.
Now are you trying now to blame it on the court or the court?
No, ma'am. No, ma'am.
Okay, then
I am not.
let's
That
move
is my
on. Let's move on then. All right. You had this case, the first appearance, it looks like was set for August 7th of the year 2025. The incident of driving without proof of insurance dates back to April 7th of 25. This is a B misdemeanor. I would remind you that it requires a fine of at least $300 up to $1,000 and up to a possible 6 months in jail. Probation is an option. You do have the right to attorney. You've heard all of this multiple times. I've given you time to hire an attorney, and I've told you if you can't afford to hire an attorney, you can apply for court appointed. You may have even done that. I talked to you about diversion.
Yes, ma'am.
You said you were going to look into diversion. Did you do that?
And I applied and I got denied. Sorry for interrupting.
No, that's fine. That's what I wanted to know. All right. What are you going to do now about this? Are you going to waive your right to an attorney since you haven't gotten one, or what?
Yes, ma'am.
All right. You know you have the right to, in this case, apply for court appointed if you cannot afford one, and you have not done so. Is that right?
Correct.
So now you want to proceed on your own behalf?
Yes, ma'am.
Basically waiving your right to an attorney?
Yes, ma'am.
Is anyone making you waive your right to an attorney?
No, ma'am.
You feel like anything I've said so far has compelled you to waive your right to an attorney?
No, ma'am. I just,
All right. I will find that you've knowingly and voluntarily waived your right to an attorney. And how do you want to proceed? You can plead.
I plead no contest to it.
You can plead not guilty, and we can still set this for trial. And that would give you additional time to get an attorney. You could plead guilty, be found guilty with sentencing today, or you could plead no contest, as you just told me you wanted to do. No contest is how you want to plead?
Yes, ma'am.
Do you know that means you don't want to admit the charge, but you don't want to deny it and take it to trial?
Correct.
Are you pleading no contest without anyone forcing you again? Is anyone forcing you? Do you feel forced? Do you feel forced to enter a plea today of no contest?
No, ma'am.
And you know that you will be found guilty having given up your right to trial.
Yes, ma'am.
All right. I accept your plea of no contest as freely and voluntarily given, knowingly given. Mr. Regier, any factual basis to support it?
One moment, Your Honor.
I'm just ready to get this over with. And
Well,
unfortunately,
I don't want you to plead to anything that you don't believe and just to get it over with.
I know.
All right, well, just hold on, you've done your part. Mr. Regier has to show me that there's a basis to find you guilty of driving without insurance.
Yes, Your Honor. Were this case to proceed to trial, the state's evidence would show that on April 7th, 2025, within the applicable statute of limitations, a stop occurred involving a Nissan Altima at 100 South Andover Road. State's information is that is within Andover city limits, well within Butler County boundaries. Besides citing the defendant for one violation of KSA 43104, the officer specifically noted in the officer's notes attached to the ticket, quote, "No insurance given."
I find the defendant guilty of driving without proof of liability insurance. Recommendations for sentencing.
Yes, Your Honor. In this matter, the state is prepared to recommend the minimum fine required by law of $300 and impose appropriate court costs and a suspended jail sentence of 120 days. The state has no objection to the court ordering a probation for a period of 6 months. The state will defer to the court as to make a finding as to whether or not that should be reporting or non-reporting probation, given the prior history of this defendant in light of Butler County 12 TR 4772 for the reasons previously addressed on the record. If the court does determine that a reporting probation is appropriate, the state will be, of course, recommending all standard conditions, including a $60 probation fee.
All right, Ms. White, when you failed to appear a while ago, the state informed me that you had a case 12 in the year 2012, 12 TR 472. That was issued in March or April of, well, I think 2014, but that would be a while.
And Your Honor,
That doesn't add up.
for the
Yes,
court's edification, it does appear in that prior case, an information was filed with the court. That information does appear to have a file stamp dated December 20th, 2012, with a journal entry of conviction and sentencing subsequently filed with the court from a hearing approximately 5 to 6 years later on January 24th, 2018, with a file stamp dated February 6, 2018.
Okay, thank you. All right, so it was 2012 TR 472 because the charge was formally filed December 20th of 2012, but you kind of disappeared, and it took it till January of 2018 to get resolved, 6 years. And this case looks like it's kind of starting to follow in that same footsteps with its age. So, Ms. White, normally I would put you on non-reporting probation, but I want to see this thing get resolved. So I'm going to put you on reporting probation.
I was going to ask you to put me on non-reporting probation because, again, I work at a school district. I can't just up and not show up for a day. And unfortunately, right now I am in a cast on my foot. So I can't drive anyway. So I'm not gonna be able to work or drive anywhere.
Then maybe I ought to just put you in jail and not grant probation so that you don't have to worry about driving or moving or
No,
getting
ma'am.
to school.
No, ma'am. I would rather not. I have 4 kids to take care of. I need to be with my kids.
Well,
I promise I will not let this hang out for 6 years. I will pay it. Every paycheck that I get, I will pay something towards my costs just to get it done and over with.
Well, you've already killed a year of it. You've already been dragging it out a year. Only 5 more to go and you'll be at 6.
No, ma'am, it will not take that long.
Well,
I have a job. The issue was, back in 2012, I was not mature enough to realize my mistakes in life, and I just kind of blew it off. I have changed that, and I know it doesn't look like it, but I have a job, I have kids, I have people that rely on me.
Okay, do you realize it's been 13 years since you started that other case? And it took you 6 years to start it? And now
Yes,
you
ma'am,
started this case and you've downed another year?
It's not gonna take that long to pay the court cost off.
Well, here's
Like I
what I'm
said, I want to
doing.
wrap it up and be done with it.
All right, I want you to stop talking and I want you to listen to what I'm ordering.
Yes, ma'am.
Because you're getting a $300 fine. That's the minimum allowed by law for this.
Yes,
I
ma'am.
have to order that. I'm ordering court costs of $108. Now, I may, if I give you probation, have to order a $60 supervision fee, which would total $468. How much time do you need to pay $468?
Can I get like 120 days just because right now I'm not able to work at my job. because of my cast and I'm on crutches. But I promise I can make like little payments here and there without having a job.
What do you do for the school?
I drive a school bus, ma'am.
Are you on workers' comp?
No, ma'am.
Are you married?
No, ma'am.
Do you live with someone?
I do. I live with a couple of friends and my kids.
All right, your jail sentence is 120 days. Now the question is, do I grant you probation? I'm going to give you a 6-month non-reporting probation, but you're still on probation. And if you violate that probation, you will do 120 days in jail. Do you have a question about that?
No, ma'am. Thank you so much.
All right, condition number 1 is violate no laws for the next 6 months. Condition number 2, pay the total due of 468. You said you needed 120 days. That's what I was going to give you?
Yes, ma'am.
All right, 120 days. Do you have a pencil? A pen?
Yes, ma'am.
Call the clerk of the district court for instructions on how to make your payments.
Okay.
316-322-4370.
Yes, ma'am.
Now, if you violate either one of these conditions, it can get your probation revoked and you can do 120 days in jail. I think
Do
we're
not
clear
need
on
that.
that.
Yes,
Okay.
ma'am. I do not need no jail time.
All right, and I will set aside any bench warrant bond forfeitures I just issued.
Thank
Since you
you
didn't
so
show
much.
up.
I appreciate you, Judge.
All right, well, you might not appreciate me as much if you get your probation revoked, so
I
comply
will not.
and don't make this a 6-month case. All right, Mr. Regier, anything further?
No, Your Honor.
All right, then Miss White will be in recess. You may go, but call the clerk and make sure you follow up on your payments as you go.
Yes, ma'am. Thank you so much.
You're welcome.
Have a great day.
You too. The camera on the record in BU 2024 CR 450, Stay in Fifth Kansas versus Brian Odell La Camera. Do I remember that correctly? Is it La Camera?
Yes, Your Honor.
All right, thank you. Please announce appearances.
Jared Begier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Brian LaCamera, who does appear personally via Zoom audio visual. Judge, first order of business I would ask court to entertain is that Mr. LaCamera is asking to represent himself and not have court-appointed counsel. So based upon that, I would ask the court to set my court appointment aside.
Yes, he tried to address that while you were going into a breakout room. Mr. La Camera, do you want to represent yourself in this matter?
Your Honor, I'm also representing myself in a couple other cases, as well as a federal case, writ of habeas corpus.
Do you want to be representing yourself in this case?
Yes, Your Honor.
All right, now I'm going to go over this again, as we've done before. You understand that you do have the right to hire any attorney of your choice. Do you understand that?
Yes, Your Honor.
If you cannot afford to hire an attorney, you can apply for court-appointed attorney. Do you understand that?
Yes, Your Honor.
And you have in fact applied for and been appointed court-appointed attorney, right?
Yes, Your Honor.
That would be Darren Patterson for this case.
Yes, Your Honor. I don't feel that Mr. Patterson's representing me to the best of his ability.
All right. But he is your attorney and he has been court-appointed, correct?
Yes, ma'am.
All right. And at this time, you do not want him to represent you any further, right?
Your Honor.
That was yes?
Yes, I don't want him representing me any longer.
All right, and you understand that I don't make it a practice of letting you pick and choose your court-appointed attorney. That
Your
you'll
Honor.
use Mr. Patterson because I think he is excellently qualified and he does a good job from what I've always seen. And I've seen him doing it for, what did you tell me a while ago, 30-some years? Because I was here before he was. All right. But if you do not want him to represent you, you don't have to have him. He's got plenty of other cases. Mr. Patterson, you're asking to be allowed to withdraw also?
At this time, yes, Your Honor.
All right, withdrawal is granted. And now we'll go back to you want to represent yourself. Did I understand that right?
Your Honor.
And we've been over it many times now that you understand you have the right to hire or apply. And if you cannot afford to hire, you can apply. We've gone over that multiple times, correct?
Your Honor, I fully understand.
Okay. And you don't want an attorney, you want to be your own attorney.
Yes, Your Honor.
All right. Well, I am going to grant or acknowledge and grant your right to represent yourself. Now then, as your own attorney, what do you want to do, Mr. with the camera, with this case? How do we resolve it? Do you
Your
want a jury
Honor,
trial, a bench trial?
well, I'm
plea?
formally submitting and reading into the record that the statement of law and demand for immediate dismissal pursuant to KSA 2234-3402. Any person on appearance bond must be brought to trial within 180 days, 150 if in custody, failing which the status mandates that they shall be entitled to discharge from further liability and to be and be tried for the crime charged, liability, or furthermore under Kansas case law. 1 second, I lost my place. Under Kansas Supreme Court Rule 22 and administrative governance of e-court system, the official electronic case record maintained and published on Kansas District Court Public Access Portal constitutes the verifiable public record of proceeding under KSA 223402 G and H. Any delay, trolling event claimed by the state must be legally charged and accounted for and established on that official record. The public records on the portal, uploaded and certified by county officials themselves, demonstrate zero valid defense requesting continuance or trolling events since the matter commenced in April 2025, which puts us at 500 days, with 277 of those days having elapsed since my motion for a jury trial alone. The statutory time limit has fully expired, and our unrecorded assertions, informal agreements, and continuance labeled fail to legally troll the speed of trial clock. In addition, because of these blatant statutory violations and the extreme financial hardship I have sustained over the past year, battling these invalid charges as well as the charges in other counties, I asked for my bond to be relinquished to me today. And this is also my notice to the courts that I am adding to my district court filing in federal court under Younger App's petition doctrine due to the systemic bad faith, lack of credible paper trail, and ongoing constitutional violations.
Okay, sir, who helped you put that together, that motion?
Your Honor, I have been reading every law book possible over the last year. I have proof of illegal arrest in other counties, forgery, perjury, and everything, all documented on Kansas portal. Up till my identity was stolen a year ago, I've never been in trouble with the courts before in my life. and I've been repeatedly screwed over. Excuse my language. So that's literally all I've done over the last year.
All right, so I infer that your answer is you haven't had help, did this by yourself based on what you've read and researched.
Ma'am.
Okay. Mr. Patterson didn't help you put that together?
No, ma'am.
Did you show that to Mr. Patterson?
No, I asked Mr. Patterson, or told Mr. Patterson this morning, I'd like to invoke the rule of a speedy trial, and he said that it doesn't constitute under this case because of everything going on, and that there is continuance.
Because of the continuances being at your request?
They haven't been at my request, though, Your Honor. Since the very beginning, I've told Mr. Patterson that I request the trial by jury, and I have the whole court proceedings recorded this morning, and of Mr. Patterson sitting there telling, hey, we just submitted evidence, and we want to request on the defendant's behalf that the courts, and that's not legal either. And I have the state law I have federal law and supreme what is it? 1 second, Your Honor. Because I've been looking up laws while we've been sitting here, and it's right here. California, I believe, California something. Well, the Supreme Court ruled that any in California, I can't remember the case law, and my phone's not loading right this second, that continuance on defendant's request when it's the prosecutor that's trying to investigate and look into evidence isn't legally allowed.
Okay, well, you're saying a lot of things that I would have to tell you I don't agree consistently mirror Kansas law. But let's start with try to wrap this up for today. I think that this motion you need to put in writing and give a copy to Mr. Regier so that he can have some time to see if he agrees with you or if he wants to file a responsive brief or even motion, I should say. I didn't mean brief, but he might want to file a brief. But let's just a real super quick review if we can, because we're after the lunch. We're in the middle of the lunch hour, and Mr. Regier and I have 1:30 dockets. I think no. Well, I know I have a 1 or 1:30 in Eureka. All right.
Well, Your Honor.
Hang on.
Yes,
You
ma'am.
are charged, sir. Let me just remind you, you are charged with one count. And that count alleges, quote, on or about the 13th day of March, 2024, in Butler County, Kansas, you, Brian Odell LaCamera, did then and there unlawfully make, draw, issue, or deliver, or cause or direct the making, drawing, issuing, or delivering of a check to wit a counter check on a financial institution to wit United Bank and Trust for the payment of money or its equivalent in the amount of $496.05 with the intent to defraud Bill Eberhardt, Inc., and knowing at the time of the making, drawing, issuing, or delivering of such check that the maker or drawer of such check had no deposits in, credits with, or sufficient funds in, or credits with the financial institution for the payment of such check in full upon presentation, said amount being less than $1,000 in violation of KSA 21-5821, parent little a, parent little b, parent 3, giving a worthless check a Class A non-person misdemeanor. Signed, Amber R. Norris, Assistant County Attorney. Now that was signed and filed September 24th of the year 2024. It is now July 27, 2026. You have applied for a court-appointed attorney. You received one, a very experienced attorney.
I don't agree with that, Your Honor.
And
I've sat there and
hang
provided
on,
my,
I'm talking now, sir. Let me talk.
yes,
And
ma'am.
I'll ask you when I need a response, because I will. All right, so far you agree with me, right?
Yes, Your Honor.
But for some reason, now you're telling me you want to, as you said a while ago, fire Mr. Patterson, your court-appointed attorney, and represent yourself. Is that all correct as well?
Yes, Your Honor.
And you have prepared this motion that it looks to me like you're reading this motion that has been pre-prepared, and you're presenting it as an oral motion today. Is that all correct too?
Yes, Your Honor.
When did you decide you didn't want to have an attorney?
I discussed it with Mr. Patterson right before the last hearing, and he sat there and at the end of the court hearing sat there and said that he asked me if I wanted to address the court, and I got a little nervous because I didn't have anything prepared at the time. So I told him no, and you dismissed me for that hearing and had me report today. So this time I tried getting a hold of Mr. Patterson before court last week to have a meeting, which he was already all booked up, which I do understand Mr. Patterson is a very busy man. So I was okay with that. So I prepared the motion myself, and I spoke with him this morning and informed him of everything. And he still denied to the motion for the speedy trial dismissal. So that's why I asked him at that point if he would dismiss himself, because I've given Mr. Patterson the proof of my identity theft back when he first was court appointed to me, and him and Mr. Regier have denied.
Have you ever gone to the law enforcement division of the jurisdiction that your identity was stolen in and said, hey, I'm a victim of a crime?
Yeah, I've done all that. I have letters from Chris Kobach's office, the Kansas Attorney General, denying any help. I've reported it to the FBI, KBI, and nothing's ever came of that. I have reports with the OCC
What
and
is
CFPB.
OCC? I don't know OCC. That's one I don't know. I know KBI, Kansas Bureau of Investigation, FBI, Federal Bureau of Investigation. You said you'd gone to another federal agency?
OCC, they oversee like the
Can you tell me what the letters
CFPB.
stand for?
I'm not sure what
Where do you
hold on,
live?
I'll
What
look it up.
state are you in?
Huh?
What state do you live in?
I live in Lynn, Washington County, Your Honor.
In Kansas?
Yes, Your Honor.
Mr. Regier, do you know what the OCC is?
Your Honor, I would need to research further before I'm in a position to respond to that limited inquiry.
Well, I don't feel so bad if you don't know it, because you know all that kind of stuff. Okay. Well, are you a sovereign citizen? Do you know what that is?
Yes, I'm not a sovereign citizen, Your Honor.
Okay. Do you have any other similar affiliation?
No, Your Honor. I'm a 100% disabled veteran, and I just don't appreciate my rights being railroaded by
All right. So your
counsel.
whole complaint, do I infer correctly that the whole complaint you have today, and that you couldn't get Mr. Patterson or any of these other agencies to follow along with, is that your speedy trial rights have been violated?
The other agencies weren't for my speedy trial. It was for my
All right.
identity theft.
Oh,
My
the
speedy trial.
identity theft. Okay, fair
Yes.
enough. Fair enough. Okay. So, but you do have a complaint that the speedy trial is run in this case.
It has.
And Mr. Patterson wouldn't help you with that. He didn't agree with you.
No.
Okay. All right. Now you're offering a defense that you didn't do this worthless check. Somebody stole your identity and did it in your name.
Yes, Your Honor.
Okay. Do you know this alleged victim, Bill Eberhardt, personally?
Your Honor.
Don't just say yes or no. I don't want you getting into your case. All right. All right. So then you went to all these other agencies and said, my identity has been stolen, and they didn't offer you any relief?
No, it's not just for identity theft. It's because I have proof of corruption over Riley County, Washington County, and Leavenworth
I
County
see.
because of my identity theft. That's how I
So
was able to go
do you
on.
think that the officials in those counties are corrupt and have aided in this security fraud or
No,
this
but I have
identity fraud?
but I do have proof. The judges being friends with my accusers and my public defender being a proof or friends with my accuser, as well as like manipulation of court documents,
All right.
ghost arrest.
Okay.
I have a federal case and a case number I can give you.
All right. Are you a victim or a plaintiff in that federal case?
I'm the victim. It's my writ of habeas corpus under Younger Act's petition.
Okay, so you have a federal case. What's your underlying charge in that?
No, that's I'm the petitioner in the case.
Okay, and who's it against?
The state of Kansas, the Kansas Attorney General, Leavenworth County, Washington County, and Riley County.
Okay, you went too fast. So the petitioner, you're the petitioner versus the Attorney General,
Yes, Your Honor.
and who else?
Leavenworth County,
So you named
Washington.
the AG personally?
Yes.
Not, and then
Well, his office. Not. I
his
didn't
office.
name Chris Kobach.
Okay, and then the Leavenworth City
Leavenworth County Attorney's
County.
Office,
County Attorney. Okay, and who else?
Washington County,
Okay.
and Washington County is the entire county from sheriffs to the DA's office and judges.
All the judges are just the ones that have heard cases on you?
No, there's 2 judges.
Okay.
And then Riley County, as well as the entire county.
Like the Riley County Sheriff and so forth?
Yep.
The DA, judges, and county attorney, sheriff?
Yes.
Okay, and you said what that is, case number what?
26-CB-3233. And that was filed on July 13th, Your Honor.
Just this year? Do you know who your presiding judge over there is? Did they tell you?
I can get that for you.
Oh, if you haven't found it. Okay. Well, do you have any other cases pending anywhere besides what you just said, that federal case? I thought you said you had some county cases.
You just broke up, Your Honor. I didn't hear you.
Do you have any other cases pending in any other of the counties?
I do. The Leavenworth, I was already found guilty of. That's where the writ of habeas corpus started. And then Washington, I have an obstruction charge, which is disproven by body cam footage and a false affidavit. And then Riley County, I have another charge, but that's the one that, I mean, my DNA was illegally taken and everything.
All right.
That's all.
So do you have attorneys in those 4 cases?
No, I'm representing myself in every one of them, Your Honor, including the federal case. I'm pro se.
And you're wanting to represent yourself in this case in Butler County?
Yes, Your Honor.
You sure you don't want any legal experience? Anyone with legal experience?
I don't trust anyone, Your Honor. And the thing is when I was arrested for this case, I posted bond and was told that if I sent in my documents, that this was all going to be dismissed. And I got picked up on a warrant And they your own court or clerk sat there and rushed and got everything taken care of because it showed in her computer that is what I was told. And I sent all that back in last February.
All right. Well, have you ever had a competency evaluation, sir? And I don't mean that in any way disrespectfully.
Your Honor, I have a 185 IQ. I do seek, or I am in therapy for PTSD and anxiety and whatnot. But everything I have is in or on Kansas portal. I have not collected any other evidence other than what's in the portal itself.
Okay.
And
all right.
put in by the courts.
All right. Well.
And the thing is like I said, in this case, since my motion for a jury trial in December till now is 277 days. Just that alone requires a dismissal.
Well, let's set let's put your writing in motion and let's set that for hearing. How long would it take you to get your motion just on the issue of speedy trial?
How do I have to submit that motion? Because
yeah, I know. That's what I'm saying. How long would it take you, do you think, to get it put together?
I can have the motion put together in 10 minutes.
And have it written and filed in 10 minutes?
I can have it written. That's why I asked, how do you want it filed? I don't have access
file it electronically or take it to can you take it, just hand it to the clerk if he needs to?
I live 4 hours away, or about 3 hours.
Can you mail it? Can you mail it to the clerk?
I can fax it or email it or mail it.
I'll tell you what, Jennifer, if he calls your office, can somebody walk him through the filing process?
We can tell him that he can mail it or fax it. Cannot take it via email.
Okay, mail it or fax.
I can fax it. I have a fax.
All right, you call the clerk's office. I'm gonna give you their number. Now don't stay on there with
Your Honor.
Don't harass them. 316-322. And all you need to get from them is how to submit a written motion, and then follow their instructions. They're going to tell you a fax number, I think, or something like that, or somehow to mail it. And when they get that, they need to set a date so that Mr. Regier and I can be here and he can respond to your motion. In the meantime, once I get your motion, I'll probably be counting up the days and see if I agree with you on the speedy trial. My experience has been with the county attorney. They don't have very many speedy trial dismissals, but once in a while they do, and it's usually because they agree. So they so maybe they'll agree with you, maybe they won't. Maybe they'll see it the same way Mr. Patterson did. Maybe I'll see it, maybe I won't, but we'll have, after I get it in my possession in the computer, I will have the clerk get with Mr. Regier, and we'll get this, and we'll set a hearing, and we'll resolve this issue. And
can we set a hearing for this week? And I will have by the end of the day.
I've had so many people set motions and never file them that I'm leery of doing that.
Well, ma'am, like I said, if I've been able to navigate the Younger Apps petition and get a writ of habeas corpus with 2 active cases going on, I'm not playing around. I mean, you're a law-trained judge, so I know you know what kind of feat that is as a pro se that's never been in trouble before. So I'm not taking this lightly, and I'm not asking for much, but I honestly need my bond money. My house is being foreclosed on and everything else. And when I said I'm going through financial hardship, I'm not downplaying that at all. Unless the court could modify my bond and release part of it or something, Your Honor, but I literally can't keep doing this.
Well, your cash bond of $2,500 was posted February 4th of 2025. And I'm not going to release your bond with you, especially being out of county, and with these being the charges that they are. But let's see. Oh, the worthless check, yeah. But you're saying you didn't write that worthless check to Mr. Eberhart?
And I've given them the well, Mr. Patterson, and said he brought it up to Mr. Regier that the address on the ID that was used saying me is a federal hospital, which isn't can't be put on an ID, period, and that
Oh.
I haven't had an actual hard copy of my driver's license since 2023, which is verifiable through PennDOT.
All right,
And
I'll stop you there and ask you, do you know where this check was allegedly passed? Mr.
no,
Regier?
Your Honor.
Let me ask Mr. Regier. Mr. Regier, where was this check allegedly passed?
And Your Honor, can I say something real fast?
Not while he's distracted.
Your Honor, the affidavit in this matter does appear to refer to a specific banking institution. If that is the court's inquiry, I can certainly go further into that.
Well, I am just trying to help figure out what jurisdiction he needs to report this to if it truly is an ID. I've heard this a lot over the years. It wasn't me, it was some other dude that did it. Sometimes, once in a great while, it really was a fraud. Most times,
Well,
probably not.
I have the paperwork from the courts
Well,
in
hold
Butler
on.
County.
I want to know where the check was passed. Bill Eberhart, I think, is associated with Augusta. He's, I believe, a realtor and an auctioneer, if I'm not mistaken. So I would think wherever he said he received the check would be the person he needs to talk to, whether it be Augusta PD, Butler County Sheriff. What do you think, Mr. Regier?
Your Honor, I do not consider myself in a position to comment on that, as I do not represent the defendant in these proceedings, and I cannot give him legal advice.
But you are a prosecutor for the county, and if somebody's committing fraud in your county, I would think you'd be able to direct them to the right law enforcement agency. But I hear what you're saying. Mr. The camera, have you talked to any law enforcement agency and said, hey, I was the victim of fraud, will you investigate this?
Your Honor.
Is that okay? Who was the first agency you went to?
Butler County, PA.
Butler County, PA.
Butler County, Pennsylvania.
We're Butler County, Kansas, sir.
I understand that. Butler County, PA is where my identity was stolen.
Is that where you met Bill? Is that where Bill Eberhart accepted your check?
No, but I was living in Kansas when my ID was my identity was stolen from the police. That's where I'm from. I'm retired military. I told you that, but I have reported it to Washington County, Kansas.
Why don't you report it to Butler County, Kansas, and let the authorities in Butler County talk to Mr. To the guy I was just talking about that's alleged victim.
Mr. Eberhart.
Mr. Eberhart.
Well, the thing is like I was saying, Your Honor, the receipt that Mr. Regier.
I've gone way above and beyond. But if you really want to maintain that you're the victim of ID fraud, you either need to go to your defense attorney, which you just fired, so you can't go there, or you need to go, and I use that term just fired loosely, or you go to the Butler County Sheriff's Office. Call the Butler County.
I don't have transportation.
Butler County.
I understand that, Your Honor.
Call the Butler County Sheriff's Office, and I'm going to leave it, and then I'm going to set you a motion date, and if you don't have your motion on file, I'm not going to play this anymore. So,
yes, Your Honor.
Jennifer, when's a good date for a motion hearing? About 60 days out. No, let's go 30. I want to get this thing resolved.
One moment, let me see what you have in 30 days. Your schedule's pretty tight.
That it is. I don't get to see it till time to live it, but I know it's time.
August 31st, Your Honor.
August 31st, what time?
I apologize, Your Honor. Did you hear my answer?
No, I'm sorry, I didn't.
Oh, I'm sorry. August 31st at 9 a.m.
All right, now, Mr. LaCamera, I am going to order that you get that motion filed within a week. I'm also going to order that you appear, and I don't want to hear any response. I'm ordering as a condition of your cash bond that you reappear here in person at the courthouse, August 31st, 9 a.m., ready to proceed on that motion. And I'm going to be up front with Mr. Regier and with you. I may need to get a competency evaluation on you to make sure that you are understanding what's happening, what the consequences are, all the drill. I just need to make sure because I don't want you being stuck out there trying to represent yourself if you're not able to do that. All right, Mr. Patterson, anything further?
And Your Honor,
Yes, sir.
just to be clear, given that this is a defense motion, the state is requesting a ruling that this time in the interim will be assessed against the defendant.
Yes, and see, that's a good point, Mr. LaCamera. You have created this need for continuance.
I didn't
So
ask for
the time,
continuance, Your Honor.
what?
I didn't ask for continuance. I asked for dismissal under Kansas law.
Well, you can't just come in here and expect us to be ready to respond when you were quoting authorities that I don't believe are acceptable or legal authorities for this court to follow. You were saying, well, in California, they did this and this. Well, I'm not in California. I'm not under California jurisdiction or
That was
law.
Yes, but I did sit there and say under Kansas rule and law and read the statutes and laws.
All right, my patience is up. Sir,
Yeah.
put it in
Yes, Your Honor.
writing. Put it in writing. Send it within a week, a copy to Mr. Regier, and file the original with the court. And then be back here August 31st, 9 a.m. in person, ready to argue it.
Yes, Your Honor.
And if you change your mind and decide you want to hire an attorney, do that. I'm not comfortable really appointing you one. I'm not saying I wouldn't, but I'm not comfortable when you just dismissed a very good appointment. So, all right,
I've been asking for months for him to have this dismissed and nothing. So,
well, I don't think it should be dismissed, but we'll find out after I read your motion. If you give me some good reason to, I will. But what if you don't? If you don't give me some
Yes, Your
good
Honor.
legal reason. All right, thank you, sir. You may go.
And thank you. Thank you all. Those of you who have not gone already, you may go. Or you can stay and hang out. Listen to me say thank you to a whole bunch of people. I'm working on it right now. I have tabs open. I'm working on it. Promise. First and foremost, there's going to be a big old thank you to Specs. You know there is, right? You know it's coming. Going up for it. Thank you, Marty Duvall, Vegas Starlight, Miss Natasha Kitty CE, Vegas Starlight again, Northwest, all the bits and bops and all the fun little things. There was even a Vegas Starlight even threw in a little a husky there. I love those little huskies, those little guys. Spec said, look who got her bank back. And she comes back with banking again. Yous all are welcome. Thank you so much, Specs. Tracy says, let's keep this going for another super chat. And they kept it going. You know how it goes. Specs came back again with a big spender, follow, like, etc. So thank you so much. Very much, Specs. I can't say thank you enough. Bad Boy is back with the Wolfie and the cone, and Spec gave another $1 just to give another $1 because Spec is awesome. Just how it goes. Join us again tomorrow around 8 p.m. Central, 9 p.m. Eastern. Same Wolf time, same Wolf channel. I'll be doing the same thing again with different courts, different judges, different situations, with all cautionary tales that we can all learn from. There's not enough cautionary tales that we can. Boo! Specs came back with another super chat saying, boo! I don't know what I did, Specs. I apologize. Whatever I did, it must have been wrong. I try to get it right, but even when I get it right, I get it wrong. Mark Baggett was here tonight. Mikey the Legend was here tonight. Oh my God. How blessed are we? And I mean that sincerely. I honestly do. Had those guys, had OSG hanging out in here, had all you crazy, fun, interesting people like Marty and Charlene, Felix, Mama, and Jurist. All you wonderful people. Xfinity has decided to start going nuts right now at the very end of the show. I'm watching the bitrate plummet as we speak, right here on OBS in front of me, and it's absolutely annoying me to death. Meow. You know what I mean? Meow. Meow. That's right. Thank you so very much for hanging out with me tonight. I'll be back again tomorrow. I'm your lone wolf Oosel. I am the weirdo who puts together these court cases and these cautionary tales in hopes that we all find some way to learn from all of these mistakes. And some of them, not so much. Come by Saturday. I've already got Saturdays planned out. It's going to be amazing. For now, I am out. Stick around, I'll tell you what it is. It's Judge Simpson. And remember, only you can take a bite out of crime. Bye! Yeah, it's Judge Simpson. Like I said. I don't even remember how I make my own dadgum videos. So, it's Judge Simpson. He had a guy who was being accused of stalking, and there was a whole incident that happened at some workplace. It's a really long preliminary examination. It is super interesting. That, my friends, is on deck for Saturday. We're starting at 11 a.m. Central Standard Time because it is a long one. So come with your brunch, come with your coffee, and be prepared. It's a good one. Bye.